as you noted, the case was 8-1. Only Justice Thomas dissented, and that really shows I think, the soundness of the constitutional analysis finding this regulation of domestic abusers to be constitutional, and also just the common sense behind it. The Second Amendment obviously states a constitutional right. The Supreme Court has held that right is not unlimited. And although the Supreme Court 2 years ago in a case out of New York called Bruin said that there had to be some sort of historical similarity in order for a present day gun regulation to pass constitutional muster, there didn't need to be an exact historical twin. And Chief Justice Roberts, in the opinion that was released today, said that in that Bruin decision from 2 years ago, they weren't trying to create a law trapped in amber, that there could be circumstances when there wasn't an exact historical twin, like in this case with domestic abusers. And that didn't mean that the law must be struck down. If it fit with the purposes and the traditions that went into firearm regulation at the time of the founding and the drafting of the Second Amendment, then it could be constitutional. And here the court said, yes, this restriction on domestic abusers having firearms is constitutional under the Second Amendment.
Elizabeth, surely there are people out there who may just have some questions around the idea that the court could rule this way by such a wide majority, as we've pointed out, 8-1, on a case involving guns, having just last week shot down the federal ban on bump stocks. And if all of this surrounds the idea of danger, something that could be attached to a weapon, making it more dangerous, how are these cases so separate, if you will, that the court could rule so differently on each of them?
Well, that's a really good question. And I think that it's correct for the American people to be watching the Supreme Court and scratching their heads a little bit. I think that there should be no mistake. This court and its very conservative majority has been very pro Second Amendment, has looked extremely skeptically on gun regulations. And we saw that in the bump stock case, where, if you read the dissents of the more liberal justices, common sense would seem to suggest a different ruling in that case, as well as an analysis of the text and history of the relevant provisions. I think what makes the case today about domestic abusers different is that it is such an extreme argument. You have a person who is subject to a domestic violence restraining order, who has been found to pose a physical threat to another person and therefore is going to be disarmed under that restraining order. This is a very extreme case of someone seeking to or presenting a clear threat of physical harm, and that's why the gun can be taken away or the firearms can be taken away. And the court today looked through historical analogs that showed that when there's a clear threat of physical violence, people can be disarmed, consistent with the right to keep and bear arms. One thing I thought was interesting that Justice Sotomayor noted in her concurring opinion, she agreed with the majority, but also wrote to separately say, part of the reason why you don't want to look for a historical twin back to the 1700s is that, there are differences, importantly, in how society has evolved today. In fact, if you look to the time of the founding, you're probably much more likely to find legal protections for spouses who abuse their wives and not accountability. Yeah. And so the fact that today the court said, look, we're looking at the principles, we're looking at the reasons behind why the Second Amendment could be consistent with disarming a person who poses a threat, that's the key point.
Well, there's also the question of the court having to rule on situations for which there is no historical precedent, like a former president being accused of many felonies and claiming presidential immunity. That is a decision we have yet to get out of this court. They need to do so within the next week, Elizabeth. And it's raised a lot of questions for people about timing, knowing that the ability for this particular case here in Washington to go to trial before the election in November really does hinge on an outcome here for the Supreme Court. What do you make of the idea that we've waited so long to get an answer and we'll wait at least days more still?
The timing is absolutely key for this decision. The court could have taken could have taken the issue up earlier. Jack Smith, representing the United States in his role as special counsel, brought it to the court earlier, saying, please rule on this so we can move forward with our case in the interest of justice and the American people can have some resolution before the election in the interest of democracy. The court said, no, we want to wait. Then the court did take up the case. They scheduled expedited argument date, and then we've waited. And it seemed from the oral argument and just from the weight of the scholarship and the legal precedent that President Trump's immunity arguments will fail as a substantive matter. They're extraordinary arguments that would place him above the law in a way that has never been before countenanced in our American legal system and constitutional democracy. So the fact that the court hasn't issued that decision, it could basically give former President Trump a win through timing, even if he doesn't get a win on the merits.
Of course, you raised special counsel Jack Smith. He not only brought that case against Trump here in Washington, he also brought the case down in Florida, the documents case. And in Florida today, Elizabeth, before we let you go, Judge Aileen Cannon is holding the first in what is going to be multiple days of hearings related to an argument that Trump and his defense have brought that special counsel Jack Smith was unlawfully appointed as such. Is there any reading of the law that would suggest that he was not appointed in accordance with it?
I think this is a desperate attempt by the Trump legal team to, again, create more delays, although it seems like that case is perpetually delayed. There's really no there in that case. I think a lot of what he's doing with some of his legal strategy is, again, these delay tactics, which frankly have been fairly successful for him in running out the clock in other cases.
And of course, Judge Aileen Cannon, we should point out, was a Trump appointee, just as there are multiple justices sitting on the Supreme Court who are Trump appointees. When you look at the delay in that case in Florida, when you look at the delay all the way up to the highest court in the land, Elizabeth, should people not feel that courts are political, even if they're not supposed to be? Or is it impossible to separate the two in the modern day?
I think it is getting increasingly difficult for the American people to separate politics from justice. And that is deeply unfortunate because it's really important for the judiciary to have the faith and trust from the people that there will be impartial justice, that there will be equal justice under the law for all, regardless of whether you're the most powerful or the most vulnerable.